Understanding what happens during a traffic stop is not just about knowing your rights. It is about understanding the framework of the law that governs one of the most common interactions between the public and the police. For millions of people every single day, a traffic stop is the first and only time they will ever have a direct encounter with law enforcement. And the dynamics of that encounter can range from a routine warning to a situation that escalates into handcuffs and even arrest. The vast majority of these stops are uneventful, but the moments where they are not often stem from a fundamental misunderstanding of the legal boundaries on both sides, or from actions that inadvertently give an officer the legal justification to increase the level of intrusion. By learning the precise legal rules that police must follow, and equally important, understanding what your own obligations are as a driver, you can navigate these situations with confidence and clarity, ensuring that your rights are preserved while also fulfilling your civic duties. This knowledge transforms a potentially confusing and stressful event into a manageable interaction where you understand the script, even if you have never rehearsed it. So, before we dive deep into the mechanics of the law, let me ask you this. Have you ever been in a situation during a traffic stop where you felt something was unfair, but you weren't sure if it was actually illegal? And if so, what happened and how did you handle it? Take a moment to share your experience in the comments below, as your story can help others learn about the real-world application of these legal principles. To truly understand how a simple stop can escalate, we have to start at the very beginning, with the initial justification for the stop itself. Police officers cannot just pull anyone over for any reason. They must have what is legally known as reasonable suspicion that a traffic violation has occurred or that some other illegal activity is afoot. This is a low bar, but it is a necessary one. It could be something as minor as a taillight being out, a failure to signal a lane change, or a slightly expired registration tag. The key point here is that the stop is a seizure under the Fourth Amendment, meaning that from the moment the lights go on, your freedom of movement is legally restricted, and the officer must have a valid, objective reason for that restriction. When people ask what they can legally refuse, it is critical to understand that the stop itself is not a refusal situation. You are legally obligated to yield to the traffic stop. Pulling over safely and promptly is your first responsibility, and failing to do so can create independent charges that escalate the situation far beyond the original reason for the stop. Once you are stopped, the legal dance begins, and this is where knowledge becomes your greatest asset. The officer will approach your vehicle, and at this initial contact, they are permitted to ask for your driver's license, vehicle registration, and proof of insurance. In almost every jurisdiction, these are the three things you must provide. This is not a request. It is a legal demand that you are required to comply with under penalty of law. Having these documents ready, with your hands visible, preferably on the steering wheel, sets a tone of cooperation without sacrificing any of your rights. Now, where things often begin to escalate is in the conversation that follows the exchange of documents. An officer, while still holding your license and registration, may begin asking questions. Where are you coming from? Where are you going? Do you know why I pulled you over? Have you been drinking tonight? These questions are designed to gather information, and crucially, they are questions you are not legally required to answer in most circumstances. This is a pivotal point in the interaction. Many drivers feel a social pressure to be polite and answer, which is understandable, but it is vital to distinguish between being polite and waiving your constitutional rights. You have the right to remain silent under the Fifth Amendment, and this applies during a traffic stop. You can politely and calmly state, "I am not going to answer questions, officer," or "I prefer to remain silent." Some people choose to ask, "Am I free to go?" But during the active investigation of the traffic stop, you are not free to go until the officer returns your documents and indicates the stop is concluded. However, you are not required to incriminate yourself through conversation. This is where the line between detention and arrest begins to blur in practice. A routine traffic stop is a detention. It is temporary and limited in scope. The officer is allowed to investigate the traffic violation and ensure their safety. But if the conversation reveals evidence of a more serious crime, that detention can transform into an arrest. This transformation is often the result of the driver volunteering information that they were not legally compelled to give. For example, if the officer asks if there is anything illegal in the car and you say no, but your nervous demeanor suggests otherwise, that statement alone, even if true, can be used as a data point to build probable cause. But if you had simply declined to answer, the officer would have had to rely on other observable facts to justify moving forward. The issue of searches is perhaps the most misunderstood area of traffic stop law. The Fourth Amendment protects you from unreasonable searches and seizures, and that protection extends to your vehicle. However, there are several exceptions that police use to legally search a car without a warrant. The most common is consent. If an officer asks, "Do you mind if I take a quick look around your car?" and you say yes, you have just given them legal authority to search. This consent must be given voluntarily and knowingly. But many people feel pressured into agreeing because they think refusing will make them look guilty. The reality is that you have an absolute right to refuse consent to a search. You can say, "Officer, I do not consent to any searches." This is a powerful statement because it preserves your ability to challenge the search later if one occurs. If the officer searches anyway, after you have refused consent, they must have another legal justification. One such justification is probable cause. If an officer sees evidence of a crime in plain view, like an open container of alcohol or a visible weapon, that gives them probable cause to search the area where that evidence was seen, and potentially more. Another exception is the search incident to arrest. If you are arrested, the officer can search your person and the immediate passenger compartment for weapons or evidence related to the crime for which you were arrested. Then there is the automobile exception, which is based on the inherent mobility of a vehicle and the reduced expectation of privacy in a car. If an officer has probable cause to believe the car contains evidence of a crime, they can search the entire vehicle, including closed containers within it, without a warrant. Understanding these exceptions helps you see the legal chessboard. When you refuse consent, you are not stopping the search if probable cause exists, but you are ensuring that the officer must rely on that probable cause, which can later be challenged in court if it was weak or manufactured. The escalation from a simple stop to handcuffs often hinges on these search and seizure laws. Imagine a scenario where an officer asks for consent to search, and the driver refuses. The officer, frustrated or suspicious, might then order the driver out of the car. This is actually legal under a Supreme Court decision that allows officers to order drivers and passengers out of a vehicle during a lawful traffic stop for safety reasons. So, you can be ordered out, and you must comply. Once outside, the officer might conduct a pat-down or frisk of your outer clothing. This is not a full search. It is a limited procedure, allowed if the officer has reasonable suspicion that you are armed and dangerous. They are allowed to pat you down for weapons only. If they feel something that is immediately apparent as a weapon or contraband through that pat-down, the so-called plain feel doctrine, they can then reach in and retrieve it. But if they start digging into your pockets and pulling out items that are clearly not weapons, they have exceeded the scope of a lawful frisk. This is a subtle but critical distinction. If you are lawfully arrested, however, the rules change. A search incident to a lawful arrest is much broader. The key is the point at which the detention becomes an arrest. For a detention to become an arrest, the officer needs probable cause to believe you have committed a crime. If they are simply holding you for investigation without that probable cause, the level of intrusion must be minimal. Handcuffing someone, placing them in a squad car, or drawing weapons can transform a detention into an arrest, and if that arrest is not supported by probable cause, it is an unconstitutional seizure. This is why you sometimes see body camera footage where an officer says, "You're not under arrest, I'm just detaining you," while the person is in handcuffs. This is a legally gray area. Handcuffs are generally considered an arrest-level restraint, so using them during a detention requires the officer to have a specific, articulable safety concern that justifies that level of control. If that justification is weak or non-existent, the detention becomes an unlawful arrest. Miranda rights are another layer that people often misunderstand in the context of traffic stops. You have likely heard the phrase, "You have the right to remain silent," on countless television shows. But the legal trigger for when those warnings are required is very specific. Police are only required to read you your Miranda rights when two conditions are met. You are in custody and you are being interrogated. Custody, in this context, means that a reasonable person in your situation would not feel free to leave. During a routine traffic stop, you are detained, but you are generally not considered to be in custody for Miranda purposes because the stop is temporary and you expect to be released shortly. Therefore, officers do not have to read you your rights before asking you questions like, "Have you been drinking?" or "Where are you coming from?" However, if the stop escalates to the point where you are under arrest, meaning you are not going to be released and are being taken to the station, then any questioning after that point must be preceded by Miranda warnings. If you are in custody and the police ask you questions without reading you your rights, your answers cannot be used against you in court. This is a crucial protection, but it only kicks in at the moment of arrest. This is why it is so important to exercise your right to remain silent from the very beginning. If you remain silent during the detention phase, you are giving the officers no statements to use later. And if you are arrested and then read your rights, you can confidently state that you wish to remain silent and want an attorney. Invoking that right must be clear and unambiguous. Saying something like, "Maybe I should talk to a lawyer," is not a clear invocation. You need to say, "I am invoking my right to remain silent, and I want to speak to an attorney." Once you say that, the police must stop all questioning until your attorney is present. One of the most common mistakes people make during traffic stops is trying to explain their way out of the situation. They might argue with the officer about why they were speeding, or they might try to justify a burned-out light by saying they just bought the car yesterday. This instinct to explain is natural, but from a legal standpoint, it is almost always counterproductive. Anything you say can and will be used against you, not just in a criminal case, but also as justification for further investigation. If you tell an officer you are coming from a friend's house in a high-crime neighborhood, that statement might contribute to reasonable suspicion for a frisk. If you say you haven't had anything to drink but your speech is slurred, the officer now has a statement that can be compared to their observations. The safest and most legally sound approach is to be polite, provide the required documents, and then remain silent. You can hand the officer a card or simply state that you are not answering questions. This is not being uncooperative. It is exercising your rights. Cooperation means complying with lawful orders, such as providing your license and registration, stepping out of the car if ordered, and keeping your hands visible. It does not mean you have to participate in a conversation that could lead to your own criminal prosecution. Another area where people inadvertently escalate situations is in their physical demeanor. Sudden movements, reaching into the glove box or under the seat without telling the officer what you are doing, or getting out of the car without being asked can all be perceived as threats. An officer's primary job on a traffic stop is safety, and they are trained to react to perceived threats. If you make a sudden move, you might find yourself on the ground in handcuffs very quickly, not because you did anything illegal, but because the officer perceived a threat to their safety. This is why the advice to keep your hands on the wheel and inform the officer of your actions before you make them is so practical. If you need to reach for your registration in the glove box, tell the officer, "My registration is in the glove box. I am going to reach for it now." This simple act of communication can prevent a situation from spiraling out of control. The laws governing traffic stops can also vary significantly by state. For example, some states have laws that require you to provide your name to law enforcement, even if you are not driving, in what are known as stop and identify statutes. These laws typically apply when an officer has reasonable suspicion that you have committed a crime. In a traffic stop, the driver is almost always required to identify themselves by providing a license, but passengers may or may not have a similar duty, depending on the state. In some jurisdictions, passengers are free to remain anonymous and do not have to provide identification unless they are being detained on separate suspicion. This is a nuanced area, and knowing the specific laws in your state is invaluable. Similarly, laws regarding implied consent for chemical testing if you are suspected of DUI are universal, but have specific procedural requirements that differ. In every state, if you are lawfully arrested for DUI, you have given implied consent to a chemical test. Refusing a test after a lawful arrest can lead to automatic license suspension and other penalties, separate from the DUI charge itself. But the key is that the arrest must be lawful, and the officer must have had probable cause to make that arrest, often based on field sobriety tests, which you also have the right to refuse in many jurisdictions, though refusal can also be used as evidence of consciousness of guilt. When we talk about getting exposed fast, as the title suggests, we are referring to situations where an officer's actions exceed their legal authority and are captured on video, leading to public scrutiny and often legal consequences for the officer or the department. This exposure is a powerful check on police power, but it relies on the public understanding exactly what they are seeing. Body camera footage, dash camera footage, and smartphone videos from bystanders have become the new evidence in the court of public opinion and in actual courts of law. When a driver knows the law, they are better equipped to articulate why an officer's actions were unlawful. For instance, if an officer searches a car without consent and without probable cause, the driver who understands search and seizure law can point out that the officer lacked legal justification. This knowledge transforms a passive victim of an unlawful search into an active defender of their constitutional rights. It is not about being combative or disrespectful. It is about knowing the boundaries. You can say to the officer, "I do not consent to this search, and I am recording this interaction." That simple statement creates a record that can be reviewed later. The escalation to handcuffs often occurs when an officer feels their authority is being challenged, even if that challenge is simply the exercise of a constitutional right. There is a difference between being assertive about your rights and being obstructive. For example, if an officer orders you out of the car, you must comply. If you refuse to get out, you can be physically removed and charged with obstruction or resisting. But once you are out, if the officer asks to search your car and you say no, that refusal is not obstruction. It is the exercise of your Fourth Amendment right. The officer may not like it. They may try to pressure you by saying, "If you have nothing to hide, you should let me look." But that pressure is psychological, not legal. You are legally entitled to say no. The challenge for drivers is maintaining composure under that pressure. The officer has a badge, a gun, and the authority of the state behind them, and it can be incredibly intimidating to say no. But remember, saying no respectfully and calmly is your right, and it is not a crime. Another common mistake is consenting to a search of your vehicle because you think the officer will just get a warrant anyway. This is a misunderstanding of how warrants work. To get a warrant, an officer must go to a judge, present sworn testimony or an affidavit establishing probable cause, and then get the judge to sign off on the search. This takes time and effort, and many times the officer does not have enough evidence to meet the probable cause standard required for a warrant. By consenting, you hand them the authority they might not otherwise have. This is why refusing consent is so powerful. It forces the officer to rely on their own observations and legal justification, and if that justification is weak, they cannot proceed. If they do proceed without a warrant, without consent, and without probable cause, any evidence they find can be suppressed in court under the exclusionary rule, meaning it cannot be used against you. This is the ultimate remedy for an unlawful search, and it exists specifically to deter police from violating the Fourth Amendment. Practical safety and legal guidance in these situations always points to a few core principles. First, remain calm. Take deep breaths, keep your hands visible, and address the officer politely. Second, remember that you have rights, but you also have responsibilities. You must provide your documents. You must comply with lawful orders. Third, you have the right to remain silent. Use it. You can say, "I am choosing to remain silent and would like to speak with an attorney if this goes further." Fourth, you have the right to refuse consent to a search. State it clearly. "I do not consent to searches." Fifth, you have the right to record the interaction, provided you do not interfere with the officer's duties. In many jurisdictions, it is legal to openly record police in public, and a traffic stop on a public road is a public place. Informing the officer that you are recording can sometimes change the dynamic, as it adds a layer of accountability. It is also important to understand the role of the judiciary in all of this. The courts have established a complex web of rules governing traffic stops, from the initial stop to the search to the arrest. These rules are designed to balance the government's interest in enforcing the law and ensuring officer safety with the individual's right to privacy and freedom from unreasonable government intrusion. When an officer violates these rules, the courts are supposed to provide a remedy. But that remedy only comes if you know the rules and can articulate the violation. This is why legal education for the public is so vital. It democratizes the law and empowers individuals to be active participants in the justice system, rather than passive subjects of it. Consider the concept of duration. A traffic stop cannot last longer than necessary to address the original violation and any incidental safety concerns. If the officer has issued you a warning or a ticket and has returned your documents, the stop should be over. If the officer continues to detain you after that point to ask more questions or wait for a drug-sniffing dog, that continued detention must be supported by reasonable suspicion of other criminal activity. If it is not, you are being unlawfully detained. You can ask, "Officer, am I free to go?" If they say yes, you may leave. If they say no, and they have no legal basis to hold you, you are being illegally detained. This is a very high-level legal concept, but it plays out on the side of the road every day. The use of drug-sniffing dogs during traffic stops is another area where the law has evolved. The Supreme Court has ruled that if a traffic stop is already lawfully underway, bringing a dog to walk around the car does not extend the stop beyond the time needed to complete the original mission, as long as the dog arrives during that time. However, if the stop is completed and the officer then holds you to wait for the dog, that is an unconstitutional extension of the stop unless they have reasonable suspicion to detain you further. This is a subtle but crucial distinction. detention. If you have been given your documents and told you are free to go, but then an officer asks you to wait for a dog, you are being detained without legal justification unless they have reasonable suspicion. You can decline to wait, but doing so may escalate the situation, as the officer might then try to manufacture reasonable suspicion. This is one of the gray areas where practical reality meets legal theory, and it highlights the importance of having a calm, respectful, but firm demeanor. When we talk about handcuffs, we are talking about the ultimate symbol of lost freedom in that moment. Being handcuffed is traumatic and scary, but even in handcuffs, you have rights. You have the right to remain silent. You have the right to be free from excessive force. If the handcuffs are too tight and causing pain, you have the right to say so, calmly and clearly. I am not resisting, but these cuffs are too tight and are hurting my wrists. This statement creates a record and puts the officer on notice. If they ignore it, and you suffer nerve damage, you have a potential claim. The key is to never resist physically. If you believe the arrest is unlawful, your remedy is not to fight the officer, but to fight the case in court. Physical resistance will only lead to more charges and a greater likelihood of injury. The aftermath of an escalated stop is just as important as the stop itself. If you believe your rights were violated, you need to document everything. Write down everything you remember as soon as possible, including the officer's name and badge number, the agency, the time and location, and the names of any witnesses. Preserve any video footage. File a complaint with the agency's Internal Affairs Division. Consult with an attorney who specializes in civil rights or criminal defense. They can advise you on whether you have a case for a motion to suppress evidence or a civil lawsuit for damages. This process is how the system corrects itself, but it only works when individuals take the initiative. The role of fear in these interactions cannot be overstated. Many people are afraid of the police, and that fear can cause them to act in ways that are against their own best interests. They might talk too much, trying to prove they are a good person. They might consent to a search because they are afraid of what will happen if they say no. They might run, even if they are innocent, because they are terrified. This fear is a real and powerful force, and it is important to acknowledge it. But knowledge is the antidote to fear. When you know what to expect, when you know what the law requires of you and what it prohibits the police from doing, the unknown becomes known, and the fear diminishes. You can replace fear with calm, methodical action. We also have to consider the perspective of the officer. They are doing a job that is often dangerous and unpredictable. They have to make split-second decisions based on limited information. They are trained to look for signs of deception and danger. When a driver is nervous, it can be interpreted as a sign of guilt, even though nervousness is a completely normal response to being pulled over by a police officer. This is why it is so important to project calm. Keep your hands on the wheel. Make slow, deliberate movements. Answer the required questions politely. When you do this, you are giving the officer no reason to suspect you are a threat, and you are reducing the chances of escalation. The intersection of race and traffic stops is a deeply important and legally relevant topic. It is an unfortunate reality that people of color are disproportionately stopped, searched, and arrested during traffic stops. This is not just a social issue, it has legal implications. If you believe you were stopped because of your race, that is a violation of the Equal Protection Clause. Proving it is difficult, but it is possible, especially with data and evidence of discriminatory patterns. For the individual driver, the advice remains the same. Know your rights, exercise them calmly, and document everything. The fight against racial profiling happens in the courts and in the court of public opinion, and evidence from body cameras and dash cameras is critical in that fight. In terms of what you can legally refuse, let's break it down clearly. You cannot refuse to pull over when signaled. You cannot refuse to provide your license, registration, and proof of insurance. You cannot refuse to comply with a lawful order, such as stepping out of the vehicle. You can refuse to answer questions about your travel plans, your activities, or anything else beyond your identity. You can refuse to consent to a search of your vehicle. You can refuse to consent to a search of your person beyond a pat-down for weapons if the officer has reasonable suspicion you are armed. You can refuse to perform field sobriety tests, though you must be aware of the implied consent laws for chemical testing after an arrest. You can refuse to sign a citation, though signing is not an admission of guilt, merely a promise to appear, and refusing may lead to arrest. You can refuse to be recorded by the police, though they often have the right to record you in the performance of their duties, and you have the right to record them, within reason. The concept of reasonable suspicion versus probable cause is the engine that drives these interactions. Reasonable suspicion is a lower standard, requiring specific and articulable facts that would lead a reasonable officer to suspect criminal activity is afoot. It justifies a stop and a limited frisk for weapons. Probable cause is a higher standard, requiring facts that would lead a reasonable person to believe that a crime has been, is being, or is about to be committed. It justifies an arrest, a search, and the issuance of a citation. Understanding the difference helps you evaluate the officer's actions in real time. Is the officer frisking you? They need reasonable suspicion you are armed. Are they arresting you? They need probable cause you committed a crime. If they lack that, they are acting outside the law. One of the most educational aspects of this topic is understanding that you can be polite and firm at the same time. The idea that asserting your rights is inherently confrontational is a myth perpetuated by those who benefit from your silence. You can say, "Officer, I respect the work you do, and I am going to comply with your lawful orders. I am providing my license and registration. I am not going to answer any questions, and I do not consent to any searches." This is a perfect response. It is respectful, it acknowledges the officer's authority, and it clearly and unambiguously asserts your rights. It leaves no room for misunderstanding. The role of the courts in shaping traffic stop law is ongoing. Every year, new cases are decided that refine the rules. For example, the Supreme Court has recently clarified issues related to the duration of stops and the use of dogs. Staying informed about these changes is difficult, but the principles remain constant. The Fourth Amendment protects against unreasonable searches and seizures. The Fifth Amendment protects against compelled self-incrimination. The Sixth Amendment guarantees the right to counsel. These are your shields. When we look at the title, "Cops Escalate a Simple Stop into Handcuffs and Get Exposed Fast," we see a narrative that plays out on social media and news outlets regularly. What is happening in those videos is a real-time lesson in constitutional law. The driver often starts by doing everything right, staying calm, providing documents, asserting rights. The officer, for whatever reason, crosses a line. Maybe they order the driver out for no reason beyond the stop itself, which is actually legal, but then they go further. Maybe they try to search without consent or probable cause. Maybe they become verbally abusive or physically aggressive. The driver, armed with knowledge, continues to assert their rights calmly. The exposure comes when the video goes public and legal experts and the general public analyze the officer's actions through the lens of the law. The officer gets exposed because their actions do not hold up to legal scrutiny. This is the power of education. It turns every citizen into a potential guardian of their own rights and a witness to the actions of the state. It is not about being anti-police. It is about being pro-Constitution. The vast majority of officers do their jobs professionally and lawfully, and they appreciate dealing with drivers who are calm and respectful. But when an officer does cross the line, the public needs to know how to respond. The response is not with violence or aggression, but with knowledge, with a calm voice, and with a camera. In conclusion, a simple traffic stop contains within it a microcosm of American constitutional law. It involves the 4th, 5th, 6th, and 14th Amendments. It involves centuries of common law and decades of Supreme Court precedent. For the average driver, it is a test of their knowledge, their temperament, and their resolve. By understanding the legal framework, you can pass that test. You can ensure that a simple stop remains simple, and if it escalates, you can ensure that the escalation is based on lawful grounds, not on your own mistakes or on an officer's overreach. You are the first line of defense for your own rights. Arm yourself with knowledge, stay calm, and remember that the law, while complex, is on your side when you understand it. Share your thoughts and experiences in the comments, and let's continue this important conversation about the rights and responsibilities we all share on the road.